Hey everyone, welcome back to Law School 101. Today we're going to start with torts, which is one of the most important subjects in law school and on the bar exam. This video is not necessarily about memorizing rules yet. This is more so how to think. By the end of this video, you should understand what a tort actually is, how all of the torts fit into the bigger picture, why negligence is the core of the framework for torts, and how to approach a negligence analysis step by step in a way that even a 13-year-old could follow. Tomorrow I will try to break down the other torts, and then after that I'm going to start making videos on how to approach essays. So today with torts, it's just foundation, that's it. So first of all, what is a tort? If you're like me and you're coming from a background where you're not related to any attorneys and maybe a first-generation law student or a first-generation college graduate at all, you probably have no idea going into it like I did. But a tort is a civil wrong, okay? So there's a civil court and there's a criminal court. In the civil court, you pay money if you do bad. In the criminal court, you go jail a long time, okay? Like, that's the biggest difference that I can put on here. Of course, it's a little bit more detailed than that. But at the core, a tort is a civil wrong. That's it. It's not a crime. It's not about punishment. It's not about harm. A tort asks one basic question. Did someone cause harm to another person in a way that the law cares about? If the answer is yes, the law may require some type of money damages or sometimes also in order to stop the behavior. And if criminal law is about jail, the tort law is more so about responsibility, taking responsibility for your actions. So let's look at this being torts from the macrocosm, right? At the highest level, torts fall into three big buckets. Think of it as three different mindsets to switch from, right? It's either intentional torts, which these are cases that like someone was meant to do the act, someone meant to do the act, right? Like someone intentionally intended to do it. For example, they intended to hit someone, they intended to lock someone in the room, they intended to trespass on someone else's land. The key word here is intent, okay? The second is negligence. This is the biggest and most important category of torts, and this is what we're going to go in the most detail with in this video, okay? Negligence is about carelessness. It's not bad intent, but bad decisions, right? This is where the most real world cases live. So these are the car accidents, these are the slip and falls, these are the medical mistakes, these are the unsafe businesses, right? And the third category, strict liability. This is liability without fault. So even if you were careful, you can still be liable. For example, dangerous animals, if you own one, explosives for obvious reasons, and probably the biggest example is like businesses with defective products, right? So remember this hierarchy: intentional, negligent, and strict liability. These are all different mental states in different analysis, okay? So let's also talk about how torts relates to other subjects. There's a way that torts basically connects to other areas of law. So intentional torts are similar to criminal law in that an intentional tort feels a lot like criminal law, and there is some crossover, right? They both care about the intent. They both care about this voluntary action, and they both care about harm, right? The difference between intentional torts and criminal law is who brings the case. With criminal law, the government brings the case, and with torts, it's private people against each other. Same behavior, completely different system. Another area where torts crosses over is defamation and privacy in constitutional law. Defamation and privacy torts sit right at the edge of First Amendment because it's usually related to public figures being treated differently. Speech matters, truth matters, malice matters. If con law scares you or scared you, torts is where you see it play it out in real life, if that makes sense. So here's why we're going to start about negligence. Let's talk about the elephant in the room, right? Negligence is the beast. Why? Because negligence shows up everywhere. It's tested constantly, it's highly structured, and it teaches you how to analyze facts like a lawyer. If you understand negligence, everything else becomes so much easier, because negligence is not just about vibes, right? It's a checklist. And that checklist, no matter what, no matter where you are, I'm pretty sure in all states, but I am only licensed in California, so I can only speak on California. But it's pretty much every state. No matter what, the checklist is duty, breach, causation, damages. Duty, breach, causation, damages. Say it with me. Duty, breach, causation, and damages. Every negligence analysis follows that order. Always, no skipping, no matter what. Don't get creative here, okay? It's a script. Remember, law school is about a 5,000-page script that we're memorizing, and it's not the time to decide to become Shakespeare, okay? Follow the formula that is already given to you, and remember that whenever you're doing a negligence analysis, it's duty, breach, causation, and damages. Always, okay? Negligence at a higher level. Let's go back to the macrocosm, but specifically to the subsection of negligence. Negligence asks you, 1, did the defendant owe plaintiff a duty to be careful? 2, did the defendant mess that up? 3, did that mess up actually cause the harm? And 4, did the plaintiff suffer real harm? If any one of those fails, the claim fails. Negligence is like dominoes. Miss one and everything falls apart, okay? Ooh, excuse me. Detailed negligence analysis. Let's look at it from a slight microcosm. We're not going to get too deep into it, but we're going to get a little bit specific, okay? But I'm still going to try to break this down so that an 8th grader can understand it. 1, duty. Duty is about relationships. When you're approaching the analysis for duty, the law is literally asking you, did this person have a responsibility to think about someone else? In most cases, the answer is yes. If you create a risk, you owe care to the people who could be hurt by that risk. That's it. But special relationships adjust how strong that duty is. An example of special relationships: doctors, landowners, businesses, drivers, parents. I just got a message. Anyways, these are some examples of special relationships, but always, like, the start is just as simple as, did the defendant create a foreseeable risk to someone else, right? Okay, next, let's get into the standard of care. Once we know that there is a duty, which most likely, especially in the case of you being a law student taking an essay or a bar taker taking the bar, there will always be a duty because they want to see you do the analysis. Once we know that there's a duty, we ask, what does being careful look like here? Usually the answer is, what would a reasonable person do in this situation? Now, the reasonable person standard. Interesting. It's not a perfect person. It's not a superhero. It's a reasonable person. But going back to specific standards of care and specific duties, sometimes the law tweaks the reasonable person standard because, for example, professionals have a higher standard, right? Children have age-based standards, and emergencies lower expectations. But the question at the core when it comes to standard of care never changes, because the question is, what should have been done differently? Okay? 3, let's get into breach. Breach is where we compare what should have happened to what actually happened, right? If the defendant fell below the standard of care, that is a breach. This is a behavior analysis, and this is where most essays are won or lost, okay? You have to be concrete, you have to be specific, and you have to point to the facts. Did the defendant breach their duty of care based on what they should have done and what they did? Okay? That's how you get the gut of that analysis. That's how you get those points. Next, let's get into causation. So Causation has two parts. There's actual cause and there's proximate cause. So actual cause is, did this mistake actually matter? If it weren't for this mistake, would the damages have been caused? Would the harm have happened but for the defendant's conduct, right? If yes, we can move on to proximate cause. Proximate cause is where we ask about fairness. Was this the type of harm that we should blame the defendant for? Was it, and here's the key word here, foreseeable? Foreseeable harm stays. Wild freak accidents usually break the chain of causation, right? When it comes to proximate cause and whether or not something is foreseeable, you want to trace back in your analysis every single little bitty thing that led up to the action that allegedly caused the plaintiff damages, okay? Now, the last part of our four-part analysis for negligence is damages. If there's no harm that's done, there's no negligence. It's as simple as that. But even if you know from the beginning of the analysis that no harm was done, you cannot just skip past duty, breach, and causation to say, oh, wait a second here, there's no damages. Get this plaintiff out of here, okay? No matter what, you still have to go through every step of the analysis and end with damages so you can understand and you can communicate to whoever is reviewing your essay or your like whatever test that you're taking, so they can know that you understand how to perform this type of high level analysis, right? But at the end of the day, if there is no harm done, there is no negligence, right? There must be some type of real injury. And that injury can look different depending on what the facts of the case are. It could be a physical injury, it could be property damage, and sometimes it can even be emotional harm, right? Negligence does not care about feelings alone, though. There must be something tangible in the law that can be measured in order to know that you have damages, okay? So that's an overview of the analysis for negligence, specifically the subsection of the macro torts, right? We're going to do a few videos on torts. But this structure for analysis, duty, breach, causation, and damages, it matters, okay? Negligence is not just a tort, it's a thinking framework. And once you master this structure, you can apply it to products liability, you can apply it to premises liability, you can apply it to professional malpractice, and you can even apply this to constitutional law fact patterns. And this is why negligence analysis is so important as a starting point for law school, because this is like a universal, like, once you have this down, you're going to have the foundation of how to think like a lawyer and how to do analysis down, and that can be applied to so many different things. I have graduated law school 3 years ago, and I'm still using some of the analysis that I learned in my first year torts class to apply to a lot of the work that I do on a day-to-day basis as a corporate attorney / employment defense attorney, okay? So that's all for now. This video is getting pretty long, but tomorrow I'm going to move through intentional torts, strict liability, privacy and defamation, maybe all in one day. We'll see how long the video goes for. And then after that, I'm going to shift into essay structure, issue spotting, and do some sample essays. So if this video helped you slow things down and actually understand torts instead of just memorizing them, that means it worked. So please subscribe after you take a breath, and I will see you in the next video. Thank you for watching.